care. Joining me now in the studio is Roger Barron. He's a professor at the University of South Dakota School of Law. He has a strong academic interest in subrogation on personal injury claims and medical reimbursement issues. Roger Barron, thanks for joining me today on Midday.
Thank you, Kara. It's a pleasure to be here. It's just right across the street from my office to come over here.
Subrogation on personal injury claims and medical reimbursement. So let's start at the very beginning and talk about what that really means.
Well, the word subrogation describes the ability of an insurance company to, after it has paid on an obligation, to step in the shoes of its insured and collect back the money it's paid. And traditionally, subrogation has been found in property insurance. So if you have a house and somebody burns it down negligently and your insurance company would pay you, say it's $150,000, would pay you $150,000, and it would have the right then in your name to sue the person who burned it down and collect that $150,000. And if that's awarded to the insurance company, it would then get to keep it. So subrogation is the ability of an insurance company to collect money that it's already paid against the person who was responsible for the damages. And traditionally, it's always been permitted in property damage situations of property insurance. The problem area is when insurance companies started asserting the right of subrogation on personal injury claims.
Okay, but the insurance company, though, isn't suing on the personal claim. The person injured is doing the suing and being awarded money, and then the insurance company is asking for the money back, right?
That's the way that's evolved in most cases, but the insurance companies do retain the right to bring that lawsuit in case the insurer doesn't. But the way the litigation has evolved is that today the issue is the health insurer will pay medical bills from somebody who is injured, and then if that injured person who may be catastrophically injured happens to collect some money from a tortfeasor, the person who caused it, the insurance company will want that back, and that's called reimbursement as opposed to actually filing the lawsuit. But I have to tell you that at common law, subrogation on personal injury claims was prohibited. It was never allowed. It was illegal. And it wasn't until 1982 that health insurance companies, or around about there, first began trying to assert the right of subrogation on personal injury claims. And the first reported case in the United States is a Massachusetts case in 1982 that denied an insurance company, a health insurance company, the right to be subrogated on a personal injury claim, because there's lots of problems that happen when that occurs.
What kinds of problems?
Well, not all cases, but in many cases, the person who's injured just doesn't collect enough money to go around. And perhaps the most dramatic case is the case involving Deborah Shank, a case that got a lot of publicity. Deborah Shank was an employee of Walmart, and she was a normal functioning person, and she got involved in a catastrophic accident. A semi-truck ran into her, and it wasn't her fault. And she suffered severe brain damage, requires care 24 hours a day, is in a nursing home, will be in a nursing home the rest of her life. If you were to put a number on her damages, her damages exceed far above $12 million, and her health insurance plan did pay for actual medical bills of about $470,000. Now, she did pursue through her attorney a claim against the person at fault for that accident, and all that she could collect, because all the money that was available was $412,000. And so we have this person who's in a nursing home for the rest of her life, with the net recovery that she received was $412,000, yet her insurance plan demanded that she turn over every bit of that money to the plan to reimburse it for its payment of the medical bills.
Leaving her with nothing.
Leaving her with nothing.
And the courts agreed with Walmart on this.
The courts agreed because her plan was governed by ERISA. That's a federal statute enacted in 1974. And under ERISA, all state laws preempted, and whatever words the plans and their insurance companies write in the plan documents are upheld by the federal courts. And so she lost at the federal trial level, at the Federal Court of Appeals, which is the 8th Circuit, which also encompasses South Dakota, and she lost in the U.S. Supreme Court.
Because they didn't hear her case.
Supreme Court denied the cert, right, but she did present it to the Supreme Court for the opportunity to take the case. Mm-hmm.
Okay. And so let's just back up just a step and just talk about ERISA and what that is and what the governing powers of it are?
Great. ERISA is something we could talk about for a long time. It's the Employee Retirement Income Security Act of 1974. It's a very comprehensive set of federal statutes, and it was primarily passed to deal with problems with pension plans and retirement funds. Entities would set up these funds and then take the money. And so Congress wanted to regulate that. And so after a decade-long study, Congress passed this comprehensive scheme. And right kind of at the last minute of the process in passing this scheme, Congress included welfare benefit plans that employers might want to apply to employees. And so health insurance and disability income and life insurance is also encompassed by ERISA. And that came out in 1974. And in order to make this thing powerful, Congress preempts state law. So in other words, the protections that you would find amongst the various states don't apply in ERISA. And that's really important in the insurance context because historically insurance transactions have been regulated entirely by the states. And so when ERISA got enacted, it opened the door for insurance companies to come in without any restraint or regulation or any overseeing authority to look at what they're doing.
Okay. And we're going to throw out the phone number. If people have questions or comments, you can give us a call today at 1-800-524-3604, or you can send us an email question to midday@sdpb.org. So let's talk a little bit about health insurance and most of it being employer provided. So most people are under the ERISA.
I think that's right. In the United States today, the vast majority of health insurance would be through employer-provided health insurance, and the vast majority of that insurance would be governed by ERISA. Now, ERISA doesn't control for governmental plans, federal plans, political entity plans, but the vast majority, just like the Walmart case, any kind of if you work for a company and they provide health insurance for you, that's probably going to be governed by ERISA. And so you can pretty well be guaranteed today that in that plan document, which you probably didn't look at, is a provision similar to the one in the Schenck case.
You mean you have to read that plan document when you become employed?
Well, you have the option of reading it. The ones I see run over 100 pages long. Mm-hmm. They're usually 120, 150 pages. Mm-hmm. And so people just, this is part of your package, and and today, I think you find more and more that you don't really get hard copies of that. It's kind of like you can go to the internet and look at your plan document.
But they can change it and not tell you, correct?
The insurance companies and the plans can change this. There's no regulation on it. They can change it. These documents are unilaterally drafted by the insurance companies and the plans. And there's no supervision. In a normal insurance transaction, that insurance policy has to be approved by the state division of insurance. And so we have people in each state that look at these plans and make sure there's not overreaching. But for ERISA-provided insurance, there's no protection there whatsoever. Not only do they change it, but they try to make it apply retroactively. So if that provision wasn't in effect when you had your accident, they're going to put it in effect and try to say it applies to you when you did have your accident.
And let's spill the beans about the Walmart and Schenck case, because even though the courts agreed with Walmart and they were entitled to taking all of the money she received, in the end, Walmart did what?
Walmart did a turnabout, but there was much public pressure, and the case ended up on the front page of the Wall Street Journal, covered by every major news network, and finally Keith Overman, he has this little segment called Worst Persons of the World, and he started tagging Walmart as the worst person in the world on consecutive days until Walmart changed its mind, and Walmart did change its mind. It let Deborah Schenck keep all of the money and then vowed to change its plan document to not do this again for other employees who have catastrophic injuries. And Walmart has, in fact, changed its plan document. So Walmart has done a good thing.